We call this press conference as a matter of urgency based on what is being circulated in the newspaper, and we have no choice than to call this press conference today. It was on the nation's newspaper that I have abandoned the petition, me and my lawyer, and I have to correct the negative narrative that is going on. We never abandoned the petition. Our petition is strong, and we have um, a reason why we should not give up, because the election was won, and I was robbed, and we have evidences to show that we won the election. You know, and apart from that too, the person representing APC was not qualified, academically. So there's no reason for me to give up. So the narrative the nation portray um, is wrong, and this is the essence, the reason why we are here, to debunk the news. So we are still on. Only we are not really. Um, the judgment came as a shock to us, because we we have all the necessary the necessary details that will give us victory at the court. But the judge just refused to look at what is on his table and decided to give judgment based on technicalities. That's all. So, and even those technicalities that the judge based his judgment upon is not even in consonance with the law of our nation, and we will challenge it. But the essence of this meeting is just to tell you that we didn't abandon the petition. And after all, I'm not the one sponsoring the petition. People are the one paying, contributing their hard money. So I can't just unilaterally on my own abandon the people's petition. So that's why we call this um, press conference. But so the lawyer will explain more about what actually happened on Friday. Thank you very much.
Yes, the petitioners, the first petitioner, Adewale Segun Sunday, and the People's Democratic Party, as petitioners, filed a petition on the 18th of March 2023. And the petition was premised on four grounds, which is non-qualification, number one, of the candidate of the APC, and that she was not validly nominated by the majority votes, and that her election was in breach of non-compliance and corrupt practices. Now, the petition was served on the respondents, the candidate of the part of APC, and INEC umpire. And INEC responded first, and by the provisions of the Electoral Act and the first schedule to the Electoral Act, we had 5 days, but we responded by filing our response by joining issues with INEC, filing same on the 7th of May 2023, as required by the provisions of the first schedule to the Electoral Act, paragraph 18.1. We applied for the issuance of form of hearing information sheet, which is from TF007. We made payment. The application was assessed, and we made payment online. Thereabout, when the second and the first and second, which is the candidate and APC, filed their response, we equally filed our response, joining issues with them on the 10th, both of them on the 10th of May 2023. We equally applied for each of them for each of them will equally apply for issuance of a pre-hearing information sheet. Take note, the information sheet we are talking about, TF001, is not issued by the petitioners. You only applied, and it's for the tribunal secretary or it's an administrative purpose for them to issue it. It is not for the petitioners, as captured in the ruling of the tribunals on Friday. Having done that, the pre-information was served on us the same way it was served on the respondents, which is questions. These questions is contained in TF008. So you answer and you file back. We did that. The first respondent did the same. The second respondent did the same. The third respondent did the same. Later on during proceeding, the first respondent filed another answer, which means they had two answers. TF008. They now came up with several applications, interlocutory applications, preliminary objections, this motion on notice. Eventually, we were to go for pre-hearing session, and they said no, that they needed to take the application. They now filed an application. The first respondent filed two applications on the issue of abandonment that we did not apply for the pre-hearing information, that we did not apply. And I remember that day in court when we informed the court that because when you apply, you don't serve them the application letter, it is between the petitioner and the registry. We informed the court that we have done that since they want to take their application, then they not file a formal application. The matter was adjourned for them to file a formal application to that effect, which they did later on. The second respondent, APC, also did the same thing. Before we could hear those two applications, the first respondent filed another application again, all bordered on the fact that we did not comply with paragraph 18.1 of the first schedule to the Electoral Act 2022, which is applying for, which we did. Now, when we filed our counter affidavit, we exhibited the 3 application letters with the e-payment receipt for each of them, showing that payment and filing was done for INEC on the 7th of May 2023, for APC and its candidates on the 10th of May 2023, which means we complied fully with paragraph 18.1 of the first schedule to the Electoral Act 2022. Now, the matter was, the argument was taken, the applications were moved on the 21st of June 2023. By the provision of section 2858 of the Constitution, every application, preliminary objection, or interlocutory applications that affects the jurisdiction of the tribunal or the competence of the petition, the tribunal would defer its ruling till the final judgment. On the 21st of June, that was what the tribunal did. They felt aggrieved and they wrote to the Court of Appeal. Now, at the Court of Appeal, they were asking the Court of Appeal to set aside because after then, we proceeded to the pre-hearing session. We concluded pre-hearing, we went to hearing, we opened and we closed our case. The first respondent, the candidate of the part of the APC, also opened and closed his case. The second respondent and the third respondent, APC and INEC, they rest their case on the evidence of the first respondent. Now, we adjourned for adoption of final written address on the 4th of August. Now, sometimes before the 27th of July, we got notice for hearing of the appeal because they both filed separate appeals, the first respondent and the second respondent. They had 2 appeals at the Court of Appeal, and we argued it. On the 27th, the Court of Appeal, in its wisdom, delivers its judgment. In this judgment, they directed the tribunal to deliver its ruling, which he had earlier deferred till final judgment. That was on the 27th of July 2023. And while we were waiting for the action of the tribunal, we were in court on that 27th, on the 4th. And the tribunal, in its wisdom, gave its ruling. And in his ruling, dismissed the petition on the ground that having failed to apply for issuance of pre-hearing information sheet, that the petitioners have abandoned his petition. And we are lawyers and we are ministers in the temple, and we are also there to also uphold the sanctity of the temple. If we are aggrieved by decisions of a court, there are higher steps for us to take, which is the appellate courts. Whatever grievance we have with rulings or judgments will also be taken up at the appellate level. And we believed strongly that issues canvassed before the trial tribunal was not taken into consideration. And also the authorities were also cited, and all the authorities we cited to sway the tribunal, where we strongly believe we are also taken into consideration. And these are the issues that have formed the grounds of approaching the appellate courts, which is in this instance the Court of Appeal. The details of which will not be made known to the conference here is for the appellate jurisdiction to look at what we have brought before the court, because all we are pursuing is justice. And we believe that the substantive matter which was dismissed should be heard and determined in its merit, not to be aborted by technicality. In this instance, you are not saying, in fact, in one breath, you're saying we did not apply. In another breath, they said we filed early. And our position is this. Paragraph 18.1 states you apply. And there is consequence for not filing within 7 days or not filing at all, which is in paragraph sub 4, which is paragraph 18 sub 4, not filing at all or filing outside. Now you said we filed early, and my question is, paragraph 18, there is no consequences for filing early. And the Supreme Court, the Court of Appeal have all said the same thing, that for a petitioner to have filed early, it should not vitiate the proceeding. It means that the petitioner is diligent to prosecute his petition and not to vitiate the proceeding. If paragraph 4 is the consequences of not applying for pre-hearing session within 7 days or not applying at all, there is no consequence for filing early. I want to leave the details of our arguments and grounds for the Superior Court to make its findings and decision. But I strongly believe that the Court of Appeal will do justice. I strongly believe that we will go back to the tribunal for the tribunal to do justice, to hear and determine this matter, this petition, in its merit. The petition was never abandoned. The narratives out there is false, is negative. A petition that they claim to have been abandoned, hearing have been concluded. we have filed our final addresses. The same petition is claimed to have been abandoned. The same petition that the petitioners complied by filing for each of the respondents, applications were made for each of the respondents. And for those applications, the e-payments were also made. In fact, we attach these applications with the e-payment receipt as exhibit in the counter affidavit opposing, to tell the court that no, we did comply. But there are other issues. When we get to the Court of Appeal, we'll definitely get justice at the Court of Appeal. Definitely. But I want the press and everyone to know that the narrative in some newspapers, social media platforms are not true. They are not correct. The position is that the petitioners never abandoned the petition at the Election Petition Tribunal.
I am in the last February 25th General National Assembly election, I represent Lagos West Senatorial District as the coalition agent. And I want to reiterate and affirm here that it is obvious that Lagos West, the good people of Lagos West on that day of election came out en masse and they voted massively for Dikin Segun Adewale, which at the end of the day, he won the election. And I want to confirm to you all, gentlemen of the press, that the PDP in Lagos State, we are solidly behind our candidates. We know he won the election, and we will follow any level, at any length, as the second petitioner to align with him to any length at which we are going to get back our stolen mandates. And I can assure you, the party in Lagos State, PDP, People's Democratic Party, we are behind him, and we are working around the clock. We ensure that the stolen mandate is retrieved.
This still borders on Idea too. You know, I pray God, change Nigeria for good. This is a country where somebody will steal your property and still go to church or mosque and give testimony, because it's really frustrating. You've stolen my mandate just like Yayi did. You don't have to celebrate it. You have to just keep quiet. Keep quiet. I defeated her in our polling unit. I defeated her in our ward. I defeated her in our local government. I mean, what kind of nation is this where a political party will now buy an institution, buy INEC, buy judiciary? What's going on? That's the reason why we have challenges everywhere. That's the reason why she's sleeping at the parliament. Because she doesn't deserve it. She doesn't merit it. You know, the leadership will just bring somebody from nowhere and take the person to the top, and a lot of people will be suffering because of that decision. I'm really, really upset. How can you be jubilated? How can you be celebrated? How can you go and be giving testimony on something that you stole? How can you be tweeting that you won in the court that I abandoned? Why would I abandon what a victory that I won? This same person was defeated right from our polling unit. Shows that people don't want her from our ward, from our local government. And that's the reason why we're having challenges in Nigeria. When the leadership of the party, Asiwaju Ahmed, will just be promoting nuisance as leaders. That's the problem we have everywhere. She didn't campaign. There was no effort. Because she knew that the election would be rigged on her behalf. And they will rig INEC with the support of INEC and police, and they will want to go to the judiciary and do the same thing. How can we throw out our petition and telling us that the petition was abandoned when you are saying that you didn't say we fired out of time. You said we fired too early. I mean, it's not fair. I don't want to talk. I don't want to do anything. I'm very busy with my businesses. But when I hear party members calling me that I've abandoned their mandates, it's annoying. People are saying I've gone to APC to collect money. I've gone to do this, and I didn't do such a thing. I'm busy with my businesses. I'm trying to recover. I mean, everybody would start calling me. Even AIT was calling me. Why did I abandon my what's going on? Somebody came to my house yesterday and was asking me that I should settle him out of the money I collected from APC. How? I never collected a dime from anybody, except the party. I mean, the members of the party that are supporting me. I never collected a dime from opposition. People talk to me. People who call me, offer me millions. But I can't. I can't betray my party. I can't betray the people. So this thing just go to the art. It should stop celebrating and shut up. She's supposed to hide her face somewhere. Not telling people that my petition has been abandoned. It is wrong.